Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be the 10 biggest mistakes made by landlords. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio every Saturday at 3 p.m., even when we're having a 3-day weekend. If you guys were listening live, what was the name of that song? It was Bobby O'Reilly. It was released in 1971, written by Peter Townsend of the group The Who. And the inside story about that was that chorus line, which they stated, Tenant Wasteland, was actually inspired by the 1969 Woodstock Festival regarding the desolation and mess which occurred there. And of course, everyone was wasted then. The name, how did they get that name? Bobby O'Reilly. Well, it was combined by Townsend's spiritual mentor, whose name was Mayar Bobby, and also another composer that he knew, which was the name of Terry Riley, and hence the name of the song was Bobby O'Reilly. Okay, let's talk about the show format, and that is that we start with an opening topic. And then after the opening topic, those people that are in the Zoom meeting, I will call upon you. If you do want me to talk to you, please electronically raise your hand. You'll find that in the toolbar. If you don't see it on the toolbar in your Zoom toolbar, then go to a folder called Reactions and you'll be able to see it there. I do call on the people in the order that they did raise their hand. So do it now. And you'll be sure if you got a question that I'll be able to get to you before the end of the show. You guys watching on YouTube, well, thank you. And it would be appreciative if you could hit that like button and subscribe to my channel. Also, if you do want to leave comments, I will get to them, I promise. So make sure that they're specific, and always, if you got specific questions about property, make sure that you tell me what the jurisdiction is, what local rent control might apply to that one. Also, if you are in the YouTube watching this and you want to know how do I get in live every Saturday at 3 p.m., it's pretty simple. Just go to my website, evict123.com, and then you'll see the credentials on how to join the Zoom meeting. But otherwise, you can always watch it during the week because it is posted on YouTube. Anyway, let's move on to the opening topic, and that is the 10 biggest mistakes that landlords can make. The 10 biggest mistakes. So let's do the countdown. Number 1, poor tenant screening. If you don't screen your tenants well before you allow them into your property, you're going to be in a whole world of hate. As I've said on previous shows, that it's going to take 3 months, maybe longer, to get a tenant out. You probably waited a couple of months before you started an eviction case. When you finally get possession of the property and you've lost all that rent, you're probably going to have to rehab it because there's a lot of damage done by these tenants. You're going to therefore have to prep the unit and then finally lease it out. You're looking at about 8-9 months worth of lost rent. And that could have been avoided in most cases if you did proper screening. So what is that proper screening? Well, number 1, you should join one of the apartment associations, for example, the Apartment Owners Association. They can run all these checks for you that you need to run, and that includes background checks, of course, credit, and also you want to have rental history where you can tell where they've been. And we want to make sure that there's no gaps in their rental history, because that means they were probably being evicted. Some of the associations, for example, the AOA, will also do a civil lawsuit check. You want to see, for example, if this tenant has been sued by his last 3 landlords, or conversely, where he sued his last 3 landlords. And trust me, you don't want that person in possession of the property. So poor tenant screening can really put you in a whole world of hurt. And by getting the best tenant, you'll have the least chance that something's going to go wrong. You're not going to have to deal with late rent payments or property damages or the dreaded eviction case, which I am so happy to do for you. As part of the tenant screening process, you want to make sure that you ask for proof that this applicant paid his landlord the last 6 months. So I want proof of payment that you paid this landlord for the last 6 months. If he can't produce that, he's probably being evicted by that landlord, or the landlord is so thrilled to get rid of him. So you want to see proof of payments. Okay, that's number one. Let's move on to number two. The funds must clear before allowing the applicant to take possession of the premises. These people, if you make the worst rookie mistake, of course, is taking a personal check on a move-in, and of course, it's either on a closed-door account or the check is not negotiated by the bank, and on that basis, they're in possession. You've got nothing. You might want to call the police, but it makes no difference. You're going to need to go through an eviction. Even if you take a cashier's check, we've seen it where people can put a stop payment on a cashier's check. We also see it where the cashier's check, believe it or not, is counterfeit. They create a cashier's check, you're not going to know. So I don't care what instrument they give you, unless they're giving you cash, and look at it carefully so that's not counterfeit. You're not giving up the key until the funds have cleared in your bank. Okay? Okay. Number three, not understanding discrimination laws. Now, discrimination is synonymous with the word free choice, and we believe in free choice in this country. In fact, most people don't know that when leasing out a property, you are allowed to discriminate on the basis of color. Now, that might shock a lot of people, but let me tell you what the color is. The color is green, standing for economic reasons, and you should discriminate based on economic reasons. But let me tell you some of the types of discrimination that is not proper, and that is, of course, based on race or color, ancestry or national origin, religion, age, whether the person is disabled either mentally or physically. You're not allowed to discriminate based on sex or gender. You're not allowed to discriminate based on sexual orientation. And if you're in the wonderful state of California, you're not allowed to discriminate on the basis of source of income or on Section 8. You guys have to understand these criteria, and not just yourself, but anybody who works from your real estate agent or your manager. So if, for example, they call up your manager and say, hey, would you want to lease this property? It's the upstairs unit, and you know that they have children, and you're saying this is not going to be a good fit for you. The children might fall off the balcony, so I'm not going to lease it to you. If your agent or yourself makes a mistake like that, you're going to get sued for discrimination based on having children. Now, your position is, yes, but I'm only doing it because I don't want these kids hurt. Well, let me explain. That's the parents' job. If they chose to move onto the second floor with these kids who might roll down the stairs, that's their problem. It's not your problem. As long as your property was built to code, then if something happens to the children, then it's the parents who should be subjected, certainly not the landlord. But you, as a person trying not to get involved in a discrimination case, if they want to have that kid with that pool on the property, you're going to allow it. You're not going to say anything. But the one that they're getting you on most with regard to discrimination is they'll call you up and they'll say, do you take Section 8? And if you, God forbid, say no, you're looking at a lawsuit faster than you can spit. In the state of California, you cannot discriminate based on source of income or based on the fact that Section 8. And as I've said on previous shows, if you think you can reject the Section 8 based on the fact that you ran their credit and it's horrific, as of January 1st, 2024, bad credit is not a reason to reject a Section 8 tenant. It's reason to reject other applicants, but not a Section 8. All the Section 8 applicant has to do is to have the, quote, ability to pay. So if they can pay their small portion of the rent and they can prove that to you, then you can't reject them based on credit. You can reject them based on the fact that they've been evicted before, or maybe they filed bankruptcy, or maybe they've got bad references from their current landlord, but you can't summarily reject a Section 8 applicant, and you can't reject them based on credit. Now, I've told you the secret, I'll tell it to you again, and that is if for all of your units, regardless of who's renting from you, if you only lease on a month-to-month basis, Section 8 will not accept a month-to-month basis. It has to be a one-year lease. So one way around it is that I only lease on month-to-month. If I want this Section 8 tenant, but if Section 8 doesn't approve it, then it's not me, and I'm certainly not discriminating. So make sure that you and your agents know this criteria for discrimination, that you're not going to discriminate on any of those classes that I mentioned, because if you do, you're going to get sued. You'll get a DFEH complaint, which we defend all the time in our office, and it comes up very easily. So one way to avoid discrimination is to have, and it's actually the law now, to have a written screening criteria. A written screening criteria. That is the criteria that you require in order to become a tenant in your building. For example, that you have to earn at least 3 times the monthly rent, that you have to, for example, have a credit score of at least 700. This is a written screening criteria that you're going to give to your tenant. You're going to make him sign a copy so that you have his signature, or you can just put it on the back of the application that you're handing to him. By having this screening criteria in writing, if the tenant claims that you rejected him based on discriminatory practices, the answer is you can easily get out of that type of a lawsuit on the basis that, hey, this is my screening criteria. You didn't match it. You only earned 2 times the monthly rent as your income. So I was okay in not leasing to you. Now, that form, the written screening criteria, it's on my website at evict123.com. Go to the free form section and you'll be able to use that one that's there. You can make changes to your like, but nowadays with the way the difficulty in evicting tenants and not knowing whether they've been evicted before, based on the fact that this data is hidden by the courts based on our legislature's rules, I would make your screening criteria higher. Also, technically, you're not allowed to take an application fee under the new law unless you first gave them this written screening criteria. Again, I like this idea because it prevents tenants or applicants from suing you for discrimination. Okay, what's the next mistake that landlords make? Number 4, mishandling security deposits. Everybody knows to take a security deposit, but God knows that landlords don't know what to do with it when the tenant vacates. Under the new rules, unfortunate new rules, whether you're leasing a furnished or an unfurnished unit, the maximum that you can charge on a security deposit is 1 month's rent. The security deposit is equal to 1 month's rent only. The only exception to that would be if you have a total of 2 properties with a maximum of 4 units, then you are allowed to charge a security deposit equal to 2 months' rent. Now, if you have 2 3-unit buildings, one way around that would be to put one of those buildings into an LLC. So therefore, there's different owners, and you would be able to charge a double security deposit for each of those buildings. Now, you do know that you have 21 days from when a tenant vacates to send that tenant a written itemization as to what deductions, if any, you're taking from the security deposit. You're supposed to mail that to his last known address. And if you don't know where he moved to, the last known address would be the premises that he just left. You've got 21 days to do that. Under the new rules, you have to take pictures when that tenant vacated the unit. You take pictures of the condition of the unit, specifically those things that you're going to deduct from the security deposit. And then once the unit is restored, then you take pictures of the restoration of that unit. Those pictures and any receipts where the receipts exceed $125 or more must be included in the security deposit itemization and mailed within the 21-day period. Okay, let's move on. Number 5, not knowing state and local rent control laws. These people, they buy these property and they think, gee, I got 10 units. I bought the property and I did all my due diligence. The foundation was great. The roof doesn't leak. And I got all the rental agreements. I know everything about this property. So I'm just going to serve, a 60-day notice to everybody to move out, or I'm going to raise the rent, $200 because they've got no clue about rent control. Every municipality in the state of California has rent control. It's called statewide rent control. And if it's not statewide rent control, then local rent control would take precedence if there's a local rent control. People are just dumbfounded, not knowing, for example, that, hey, I have a duplex, I'm under statewide rent control, and I'm selling it, and I got to get the tenants out. That's not a ground to evict. So you need to know the rules regarding statewide rent control. In Orange and Los Angeles County, for example, the current rent increase is 8%. It's calculated on the basis of 5% plus whatever the CPI as published in April of each year, and then stated as of August when you're allowed to then do the rent increase. Now, under statewide rent control, if that's what your property is, and brokers make this mistake all the time, if it's a single family home or a townhouse or a condominium, it will not be subject to statewide rent control, but only if there's a paragraph in that rental agreement that says it's exempt from statewide rent control. That paragraph, of course, is contained in my rental agreement, which is online and free, again, at evict123.com. But then you come to more abusive cities, which have much stricter rules. For example, San Francisco or here in Los Angeles area. And you've got to know exactly what the rules are. For example, some of these municipalities, such as Pasadena, Los Angeles, unincorporated areas of LA County, they require that you have certain notices posted. If those notices aren't posted, in some situations, you will lose an eviction case where the tenant hasn't paid rent in the last 6 months. Also, some of these municipalities require that you register the unit on a yearly basis. Unit isn't registered, you start an eviction case, you're going to lose. Also, some cities, like the city of Los Angeles, or even my good friends in Pasadena, require that you pay yearly interest on the security deposit. If you don't pay that yearly interest, you start an eviction case for non-payment of rent or for any reason, you're going to lose that case. For the city of Los Angeles, if you want to know what the yearly interest is from year to year, if you go to my website, go into the legal issues section, you'll see the chart there that I have that. But again, this is not knowing the either statewide rent control rules or local jurisdiction rules. And again, you don't have to know everyone's rules just where your property is located. If your property is located in the city of Glendale, God bless you. Go to the Glendale rent control statute and read it. For example, it doesn't apply if it's 3 units or less. You've got to read all these statutes, but just the ones that you're not familiar with. And all of these local rent control cities or jurisdictions do have a helpline that you can call and you can ask them. So if you can't interpret what you're seeing on the website, or you don't want to call me because we're happy to answer those, then your next best is to just call the city like Glendale or Santa Monica or Pasadena and ask them what the rules are. And please don't make the mistake of increasing the rent beyond what you should. That's a ticking time bomb. That means that every rent increase you give after that illegal rent increase will be improper as well, even if you stick to the formula. And then years down the line, you're going to get subject to a lawsuit for attorney's fees, and you're going to have to return all this money. Also, for example, understand that under these local rules, like Los Angeles, if you rent out a unit that is not permitted, oh my God. In the city of Los Angeles, you would have to pay up to $26,000 in relocation. And of course, the tenant has no obligation to continue paying the rent during this period. Now, if you rent out an illegal unit that's only subject to statewide rent control, not the biggest deal. You only have to pay 1 month's rent. But for cities like Los Angeles or unincorporated areas of LA County and other municipalities, If you rent out this illegal unit because you didn't know the law, then you are going to have to pay substantial relocation. Now, under a state law, it's really not that difficult to get a permit for that garage that you converted. They'll allow you to do it. Yes, you're going to have to hire a contractor and get the proper permits, but trust me, you don't want to rent out an illegal unit. Okay, number 6, ignoring maintenance and repairs. If a tenant asks you to fix something, what a shocker. Fix it. Don't wait till next week. If a tenant says his pipes are clogged, call the plumber. Get him there the next day or maybe even the same day. You need to do this to protect yourself because by letting code violations accumulate or the tenants are demanding things to be fixed and you don't, you're just subjecting yourself to habitability lawsuits. That's the new thing that landlords are experiencing, where they're getting sued by attorneys. Now, these attorneys, they're just marauders. They can't find the personal injury cases anymore because the market is so tight. So now they've moved on to another deep pocket. You know that deep pocket? That's you, the landlord. You've got a deep pocket because all your buildings are worth millions. You know it, I know it, and God knows it. And they're coming after you. If a tenant asks you to fix something, fix it immediately. And also make sure that you send them a note quickly saying, hey, you asked me to fix the garbage disposal on Tuesday. I had it fixed on Wednesday. Thank you for keeping me informed. You've got to do this. Otherwise, you're going to be subject to a habitability lawsuit. The next mistake, number 7, not making regular inspections of the unit. You need to go into a unit at least twice a year, change the filters, look at the smoke detectors, see the small methamphetamine lab that your tenant has constructed in the living room. You need to go in there and take a look at this. By going in there, you're also going to stop these habitability lawsuits because if something legitimately needs to be fixed, you're going to fix it. Now, some instances, the tenant is not going to let you in, and they technically, though there's a debate under the law, they don't have to let you in for just a general inspection. I think there's ways to get around it. But if the tenant refuses your entrance to make a general inspection, write them back a letter and say, I tried to get in for this inspection in January and you refused my access. So I really don't know if anything's wrong with your property because I would certainly love to fix it. But I'll be asking again in July. And keep doing this and keep writing this. This way, when they try to pin you down with this habitability lawsuit, you've got this wonderful record. And by the way, that's number 8. You're not keeping proper records. You need to document everything. Every repair that I made, every communication that the tenant gave to you, you keep. When you finish a repair, write the tenant a note. You've asked me to fix, the window on this date. I took 2 days. I got it fixed. Thank you very much. You've got to keep these records. A landlord without records is basically defenseless in these types of disputes. Defenseless. Keep records forever. Keep text messages. Any documentation. As I say, even if you pass the tenant in the hallway and he says hello to you, document. Okay, that one you don't have to do. But the rest of them I do want you to do. The next one, number 9, not giving rent increases to keep the property at market rent. Every time you legally have the right to raise the rent, you do it to the maximum amount allowed by law or what the market value is. If you're not sure what the market value is, go to a website, which I've talked about in the past, which is rentometer.com. That's RENT, the letter O, meter, METER.com. Go to that website. It's free for the first 5 times. So I have a subscription and I love the product. And they don't give me any remuneration, which they should, but I've never asked for it. But this way you'll be able to punch in your address, how many bedrooms, what kind of a property it is, and they'll punch back about 20 different comparisons right in your neighborhood of what your fellow landlords are getting for your units. Make sure that your rents are at market level. So if you're not under any rent control, like a single family home, and you can raise the rent to whatever you like, make sure your rents are at market level. If your rents are below market level and the city of Los Angeles is giving you a pitiful 3% rent increase for RSO properties, do it every single year, even if you don't think it's worthwhile, do it. And I know the tenant is so nice and he gives you cookies at Christmas. I don't care. You're every legal year that you can serve a rent increase notice, or if your property is not subject to any rent, make sure you try your best to get those rents to market value. Number one, it increases the price of your building, the value of your building exponentially. It increases your income. But the last thing is, we don't know what these politicians are going to do. They're trying to take our properties from us. Who knows if they're going to even want to get a rent rollback? You need your rents as high as they can be. Back in 1979, when I was representing landlords, rent control came into effect. And these landlords, they were like a deer in headlights. They never raised the rent. They had a two-bedroom unit for $350. I like him. I'm okay with the rent. Then rent control came in, and they were stuck like a dog. So make sure that you do the best you can every single year to raise your rents. Tenants will expect it if you do every year, and that's what you must do. Finally, we get to number 10, and that is not treating your apartments as a business. This is a business. You own an apartment house. It's a business like any other business, whether you're selling hot dogs on the Santa Monica Pier, okay, or you're selling shoes. But whatever you're doing, to treat this like a business. Do not get friendly with your tenants. You can have pleasantries with them, okay? Don't go to the movies with your tenant, okay? Because when things get ugly, they get ugly. Keep this on a professional level. That's what successful long-term landlords do. Keep it on a professional level with your tenant. You can be nice, but again, it's nice as people in business are nice. When you start getting out of that role and you're not looking at this like a business, then it's real simple. Sell your building, because if you're in business, then treat it like a business. And that, ladies and gentlemen, constitutes the 10 biggest mistakes that landlords will make. We're now going to open it up to questions and answers. And we know the rules that this broadcast is for informational purposes only and is not a substitute for legal advice. If you do want to talk to me, please raise your hand electronically. If you don't see it in your toolbar, then go into the folder called Reactions and you'll be able to see it. This broadcast is for general questions only. If you have a specific case with me, I don't want to discuss it on air. You can always call the office. And by the way, we're closed on Monday, so wait till Tuesday. And also, if you are talking to me, please leave your camera on because it really makes it much more enjoyable. Those people who are watching on YouTube, once again, please hit that like button and subscribe to my channel because it really helps me. And also, if you want to ask me questions and you're in YouTube, leave comments there and I'm happy to get to them. And with that, we're going to open it up to our first caller. That name is, it's a very short name. It's D. I'm going to ask you to unmute yourself.
Thank you, Dennis. Can you hear me?
I can.
Excellent. So I have a bit of a situation. Tenant sent me a text that did a home mold test, which detected the presence of mold in the unit, and now they're sending it off to determine the exact type of mold it might be. They're saying they suspect it might be from a leak that happened last year. It also just happens to be the same month this month that it also just happens to be the same month that they received a rent increase the previous 2 years and are set to receive one this year. So my question is, what do I do with this claim of a at-home mold test that's being sent off? And now that they've said that, am I still okay to give them a rent increase for this month for this year, or is it going to be seen as retaliatory?
Okay, so first of all, number 6 on the 10 biggest mistakes that landlords make is ignoring maintenance and repairs. So if a tenant, for example, is telling you that he's done a home mold test, you need to send a mold company in there immediately. I know it's not going to be inexpensive, but let me tell you how expensive it is if you get a lawsuit based on mold, and you're going to be sitting there trying to defend yourself. And a lot of insurance companies don't even defend on that. They exclude that from the policy. So contact a mold company that can go in and test air samples. It's probably nothing. And now you've got a complete report. So that's number one. Number two, with regard to it being considered retaliatory because you're giving a rent increase, and my response would be absolutely not. I give that rent increase at the same periodic times. And I'm going to have the mold guy in there immediately. And I'm also going to give you that rent increase the first possible second that I can.
Excellent. Thank you so much. I appreciate it.
Good question, sir. Carlos Garfias, how are you? Carlos, unmute yourself.
Yes, Dennis, how are you?
I am good, thank you. Are you driving?
Thank you. No, I'm already parked.
Good. I don't want you hitting the car in front.
No, it's fine. I have two questions. There is this apartment. It's a apartment units. One of the ladies, one of the tenant. We have noticed that every time we go in for the rent, her daughter only is the one who's coming and pays the rent. But I noticed there are another like two people now living there, and the original person, I believe she no longer lives there. We already found out that she lives in another unit in Whittier. These units are in East Los Angeles, LA County, zip code 90063. What we should do now with these people, because, and you know what the thing is that the lady is paying us the same rent with the name of the same tenant, but she doesn't longer live there. So I don't know what to do now.
Okay, well, it's very simple. First of all, I presume you have a rental agreement with that tenant who moved?
Yes. Yes.
Okay, so the rental agreement's going to state who's allowed to live there. Right now, you've got strangers living there, and your tenant is not. So we can't proceed forward with an eviction based on the fact that they brought in unauthorized persons.
Okay, so then I call you on Tuesday to start the
Please do it. I'm happy to help you with that.
And the last one, the landlord I represent, he has two units in Ball Heights, which is LA City. She's planning to sell the property soon, but she has a tenant in the back living for more than 10 years. One of the tenants is 62 years old. What is the procedure for him to proceed to sell the property to the next owner? Can we evict this person, or the other person is gonna keep the old tenant? What will be the procedure?
What city is the
recommend?
property located in?
It's in Boyle Heights, which is LA City. Rent
Okay,
control.
well, the fact that you're selling, that's going to be under LA rent control. The fact that you're
Yes.
selling the property doesn't give you any cause to evict. So the new owner will have to deal with it. If the new owner, for example, wants to move into that unit, if she's over 62 and been there for 10 years, then
Yes.
under LA City rules, you wouldn't even be able to evict her for an owner move-in. So you're basically stuck with that tenant.
Okay. So do you think the new owner might try to negotiate the price to deduct the
Yeah. Well,
relocation fee?
you can do the same thing too. You can negotiate a buyout with this tenant and say, you know what, here's $25,000. Would you leave? And if they do, of course, our office could assist you with what we call a voluntary vacate agreement. But the reality, though, is if the tenant doesn't want to take it, then that tenant's going to be there whether the property is sold or not. Anyway, thank you very much, Carlos. We are moving on to, take your hand away from your face, Jenna. How are you?
How are you?
I am good, thank you.
Okay, so I have three questions. There is a triplex in the city of LA. It's under rent control, and I have an applicant that says it's for a business, and it's not the type of business that they take a unit and do R&B, R&B, and then or give it to maybe student housing or something like that. She claims that she has a client that owns a business, and the business owner wants the lease under business.
And the answer is absolutely not. I wouldn't do that. And maybe what he's doing is he's going to have his employees live there. Is that what you think that is?
I don't know. I haven't met that
Well,
person.
if you don't know, then you got to find out. But at first blush, the answer is no. I'm only renting. I'm not renting to a business. This is a residential property. I'm renting to individuals, not to LLCs or corporations. So, and the person who's living there should be the one who is responsible. Okay?
So if, just out of curiosity, if somebody rents to a business, it means that it can be for the business owner or any employee of the business, or
It all
any.
depends the way the rental agreement is written. But again, yeah, I mean, why would it doesn't make any sense to say that the tenant is going to be XYZ Corporation. That makes zero sense.
Okay, I see. The other question is, when your criteria says that the rent should be, for example, I mean, the income should be 3 times the rent. Is it before tax or after tax?
That's a good question. I would say that it's after tax, that it's got to be that whatever their take-home pay is.
Okay.
That's a good question. I hadn't thought of that one. So,
Okay. And then
last question, darling.
last question. When it's time to do the rental increase, sometimes we sign a lease for another year, and sometimes the tenant wants it month to month only. If it's month to month, can it be more than the lease length term?
No, the length of the lease has nothing to do with how much rent you can charge.
If it's not under rent control. So
If it's not under rent control, you can charge whatever you like.
so
So
what is if a unit is not under rent control, what is the maximum?
if it's not under rent control, there is no maximum.
There
For
is no
example, a
maximum.
single family home, you can raise the rent to whatever you like. Obviously, you can't raise it so it really looks like you're just trying to evict the tenant, like I'm going to charge $10,000 per day. But again, that's why I suggest people go to that website, rentometer.com. Anyway, thank you very much. We are moving on to someone who I talked to, I believe, last week, which is just a bunch of initials, LKJLC. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hi there.
I had a question about a retaliatory eviction. I have a tenant who I'm evicting right now, and I don't want to admit it, but I am sort of retaliating. He's been a problem tenant, and did a bunch of stuff that really pissed me off. So he's on his he answered the complaint, and he picked a whole bunch of affirmative defenses, and one of them is retaliatory eviction. And
What's the basis of your eviction?
it's his creating a nuisance. A lot of the other tenants have
Well,
complained about it.
if you can prove that he's a nuisance, then it's not retaliation. Or maybe it is retaliation, but it's not illegal retaliation. Retaliation generally, for an example, would be that the guy complains to the health department, and then you then magically start raising his rent or asking him to move. That's retaliation. If you're evicting a tenant based on the fact that he's creating a nuisance, and obviously you have it backed up with other tenants in the building, he can claim retaliation. And by the way, they would check that box in every single lawsuit, even when we're going on non-payment of rent. So I wouldn't be concerned about it. But based on a nuisance, that would not in any way be considered retaliatory. That's not a proper defense for a nuisance eviction. You either have a nuisance or you don't.
So here's my concern, though. If he wins, and do I have to pay attorney's fees? Because I checked that retaliatory eviction attorney's fees are whoever prevails has to pay attorney's fees for a retaliatory eviction. That's
No, you would not. Okay, because it's not based on retaliation. It's based on the fact that you had other tenants who complained that this person was creating a nuisance. Anyway, thank you very much. We are moving on to, it just says here, iPhone. I'll ask you to unmute yourself. Mr. iPhone. Okay. We're going to move on to Sandy. How are you?
Hi, thank you. I'm wondering if you know the latest rules regarding the installation of electric vehicle chargers. The tenant has an electric vehicle and they're asking me to upgrade the electric box so that they can install a charger.
Okay, well, first of all, under California law, there has to be, I believe, and I just learned this last week, somebody called it to my attention, there has to be at least 5 parking spots on the property.
It's a single family home.
No, they don't have the right to ask you to do it, and you don't have to agree to it. However, if you do agree to it, tell them, yeah, okay, put it in at your own expense and upgrade my electrical panel. But otherwise, I'm not letting you do it. Okay, but it's not your responsibility to allow him to do it.
I'm curious about apartment buildings too. What are the
Well,
rules?
if it's 5 or more, then unless it's impractical based on the configuration of the building, you do have to allow a tenant to install an EV charging unit. It's put in at his expense. He also has to reimburse you for the electricity, which generally is around $2.50 per day. I have an electric car and I've got a charger in my garage, and I really actually like electric vehicles, but if you don't have a charger where you live, it is probably the most stupidest car to buy because there's not enough charging stations out there, as an aside. And you got to get up at 4 o'clock in the morning to make sure you can get your car charged and be in front of the line. So I do understand tenants who are getting these electric cars want to have a charging unit on the property. I had a case last week where somebody was taking an electrical cord and doing a charge out their window, which really doesn't work because unless you have 220 volts, it's like you only get on a regular 120, you get like 6 miles an hour of distance. So, but the bottom line is if you do have a building that's 5 units or more, you have to allow a tenant to put in a charging station unless it's impractical to do so. And again, it's at his expense. And if he has to upgrade the panel, then he's got to upgrade the panel and he's got to reimburse you for his daily use of electricity.
Thank you.
Thank you. Well, that was certainly a lesson on EV chargers. So let's move on to, I see Gid. I'm going to ask you to unmute yourself. GID Gid. I'm going to ask you to unmute yourself. There you go.
Okay. Hey, hi Dennis. How you doing, man?
Good.
Thank you for your service. I appreciate it. Real quick, I have a condo. Is that treated like a single family residence?
Well, is under a condo is not subject to rent limitations. You can raise the rent as much as you like, though I would wait till November when the quote state of emergency in LA County is lifted. Where is your property located?
LA, 90043.
Okay, and so that's in the city of Los Angeles. Was it built
Yeah.
after 1979 or before?
Before.
Okay, so you are subject to the rent stabilization ordinance. You do have to register your units
Yeah.
with them. You do need good cause to evict, but again, you're not subject to rent limitations because of the Costa-Hawkins Rental Housing Act.
Okay, so that was just because I was listening to you say something about single family. Two quickies. Move-in rent. Wait a minute. Move rent from family. Okay, can I increase the rent because it's a family? Because I think there's going to be more wear and tear if there's children.
In other words, you want $3,000 for this unit if there's only 3 people there, but if there's 10 people there, then I want $3,500.
No, if there's children.
Well, I mean, I wouldn't know. Then you're discriminating on the basis of children. You can do it on the number of occupants, but you can't do it on the basis of children.
Okay, I have a tenant. This is my last question. That has no credit, but she's got an excellent job, a good history. No evictions. And I'm thinking of renting to her this condo, but she doesn't have credit history because she does not use credit.
Let your conscience be your guide. I mean, she does have some credit because you can see that that she doesn't have any negative credit, right?
Right.
And she has a long-term job.
Yes.
Okay, well, let your conscience be your guide. That's a business decision, my friend. We are going to move on to Dean. How are you?
Good. Thank you, Dennis. So my question is on a fourplex in Montebello. I recently bought 2 months ago, and I'm redoing, excuse me, the rental agreements. And the the late fees on the old rental agreement say $50 a month. And a real estate agent friend of mine said, you should just change when you update the rental agreement, you should just change it to 5%. Because it's easier and then it goes up whenever the rents go up, proportionally. Is that legal for me to do, to change the
It is,
terms
but
like
you have
that?
to, it is legal, but you have to have the proper language in your late charge provision. So if you're curious, if you go to my website, you can see exactly how I've structured it. You have to have specific language. If you just stay, if you don't pay your rent by the 5th of the month, you're going to be liable for a 5% rent increase. That would be illegal in the state of California. So take a look at the language, but I don't have a problem with it being a percentage.
Okay, thanks a lot. Appreciate it.
Thank you. Moving on to Kevin P. How are you, sir?
Hello, Dennis. Thank you for everything that you do for us. So I'm calling you regarding a duplex, Los Angeles City RSO, that I purchased last year, a duplex. The one unit is vacant for about 20 years, and then the other unit has a tenant there for 25 years. The tenant is above age 62 and her daughter, who's 30 years old. Last year, when we did a estoppel statement, they only mentioned the two names. However, I noticed that her boyfriend is there all the time, so obviously he lives there. So the goal is to demo the two units and then do ground up construction. The question that I have is, do you recommend doing an eviction or cash for keys for this type of situation? What do you think?
Well, a cash for keys would be probably the best if they're willing to take it, but if they've been there that long, they're not going to take that. Secondly, do you have a rental agreement with this tenant?
Yes, we do, and it only mentions the mom and the daughter.
Okay, so we're not talking estoppel, we're talking about a rental agreement. So I would probably try that first, that they move this person in without your permission. And do you know how long he's been there?
I bought the property a year ago, and he's been there since I've met
See,
him.
the problem with that is that it might be considered a waiver. If the guy's lived there for 8, 9 years and the previous owner knew it, that might not be a good case. So
Well,
you
we do
might
have
want to,
estoppel. The estoppel doesn't change anything. That it only
well,
mentions.
that's true. On the estoppel, it only listed the two names. I think you're okay with that because now you've noticed that this guy is there. So I would definitely explore that. You might want to call the office and I want to take a look at the rental agreement and the estoppel.
Sounds good. Thank you.
And thank you. Moving on to Sonia. How are you?
Dennis, hi.
Hello.
Hi. So, quick question. When you're talking about the screening process for new tenants, if you have a couple and one party, one spouse exceeds the income and has high credit, and the other party is just okay, it's not just under 700 and not exactly meeting the income like three times.
Well, I mean,
Can
as
we?
long as the income is met totally by the people there, I think you're okay with that. And this is a husband and wife?
Yes.
Yeah, I would consider that in compliance then.
Okay, great. Thank you. Thank you very much.
Okay, we are now moving across the country to that wonderful state of
New
New
York,
York.
the Big Apple.
Yes.
Hey,
Singing the
Dennis, how are
news,
you?
huh?
Yeah, more on the security deposit pictures. I routinely have a situation where, with significant damage, where we have to give the tenant an estimate of what is going to be charged by the contractor, so that we cannot provide pictures. It's okay to provide pictures past the 21 days after the work has been done, given the fact that they already have the estimate.
Yes, I would put in the note, that's perfectly permissible, that the work cannot be done within the 21 days. This is our estimate. These are the before pictures. We'll supply the actual
Okay.
receipts and pictures once the job is completed.
Okay, and my other question about security, these pictures is I have a lot of work done on the property that doesn't affect the tenants. It's a big property. I have a building on the property that they don't have access to, fences that they don't make complaint about that are constantly being repaired. Do I have to do these pictures for work like that?
But this has nothing to do with that tenant's security deposit. It doesn't have anything to do with their unit, correct?
Well, it has to do with the fact that they're living on the property and I'm repairing fences that surround the property. That's only one
But
example.
why is that their responsibility that you could take that from the security deposit?
That's what I'm asking. They don't have to have pictures of I don't have to supply pictures of every single repair that's done on the property. Only repairs that they've requested or
Yeah,
that I.
I mean, you're only deducting from the security deposit those repairs that were required within their unit, not in the common areas.
Okay, well, yeah, okay. They have access to the whole property. It's just
Well,
that
unless you can prove that they're the ones who ripped down the
Right.
fence, then you could take that from the security deposit, but I don't think that's what you're referring to.
No, I'm just worried about whether they could come back after the fact and say, there was something on the property that they didn't report, that I don't have a picture of that,
No, it's
wasn't.
the security relates to the work that you've done inside their unit.
Okay, thanks a lot.
And thank you. We are moving on to Nancy. How are you? Ask you to unmute yourself, Nancy.
Hi, thank you for taking my call. I have a unit in Redondo Beach, and we're doing a UD for non-payment of rent. And of course, the legal aid people have asked for a jury trial. And of course, they say there's habitability problems, which this is all for non-payment of rent. And the legal aid people are being very aggressive, trying to get us to settle, before going to trial. Is that because landlords tend to settle because the process is so unpleasant, or is it because they know that the jury trials are unfair to? So I'm going to pay all this money out for lawyers,
Well,
and I'm
when
going
you
to
say
lose.
settle, is it settle on the basis that the tenants are going to have to move?
Well, if they would like to stay, but we don't want them to stay because they've had problems paying their rent before. So they would like us to give them a certain number of months of rent and to not have them pay any of the rent and not put it on their record and give them $25,000. So we said, no,
Yeah,
you haven't paid your rent. We are going to trial. But the legal aid
I
people.
probably, that offer seems very excessive. It's one thing to waive the rent and give them 30 days to move just to be done with them and not have to go through the expense of a jury trial. But to pay that kind of money is insane. So,
We agree.
I would definitely tell them no, unless there's some weakness in your case,
Nope.
which your attorney would have to review to see that. But as a general rule, I think that's an insane proposition. But I did one of the other Zoom landlord tenant talk radio shows was for a tenant going through an eviction is like winning the lottery. That was the title of that show. And you have just typified why I did that show, because the laws are such that with these jury trials. But a lot of these attorneys cave, especially on the legal aid side, and they don't want to go through a jury trial. So I know for my firm, for example, I think we're up to right now at least 18 of the last 20 cases, might even be 19, but at least 18 of the last 20 cases that actually went to jury that didn't settle, we've won. So we've got a pretty good crew there. And the other side, generally, they know the tricks and the traps, but they're usually not really great attorneys. Anyway,
And so
thank you very much.
if
Sorry, darling, got to move on, trying to get to everybody because I've got to get to Rosie Mischief. How's my good friend who saw me at the trade show?
Hi, Dennis.
Hello,
Can you hear me?
I can.
Oh, perfect. Well, I'm doing great, and I hope you are as well. And I just wanted to make sure that you knew, you talked about faster than you could spit something, one of your phrases earlier, and I want you to know that I won the cherry pit spitting contest in Michigan a few years ago. So at any rate, I've adopted tenants in a 2-story commercial building in Pasadena. I have a couple questions in general. I have some adopted therapists upstairs that apparently they can be there, and there's no elevator, and I'm a little concerned about some possible handicapped clients coming up the stairs. So we have a couple vacancies in the building on the first floor, and I'm thinking of asking them to relocate to comparable space per the terms of the agreements that I adopted. So the other idea is what you mentioned about proposing.
Well, you got to ask a question. Number one, if somebody falls down a flight of steps, that's not the landlord's responsibility at all, unless there was something, a dangerous condition which existed on those steps. If the steps are built to code and you got the handrails, if somebody trips because they're clumsy, that has nothing to do with you. However, in an abundance of caution, if you want to offer a downstairs unit to the tenant and see if he wants to take it for that reason, then I don't have a problem with that.
Well, I don't know if they're coded as medical because they are going to insurance. They are getting reimbursed by health insurance.
Well, then it's his job to know that he's starting a practice on the second floor, and that's in accordance with his rules. You're just the landlord. So I wouldn't hold yourself out as now being responsible that he's renting a place and it's not in conformity with any kind of health and safety rules for his patients.
Okay, well, thank you for that. That puts me a little bit at ease. But do you think the idea of relocating them to a first floor, just for other reasons perhaps, is better than giving a voluntary vacate agreement because the rents are under market?
Well, this is a commercial property, so if the rents are under market, then the problem is you need to look in a mirror because you can raise the rent whenever you like for a commercial.
No, these two are on leases. I've adopted their lease agreements.
Oh, okay. So they're still within the lease term?
Yes, there's two left in this building that are on leases, yes.
Okay, well, I don't know why you leased them for below market, but
No, I didn't. I adopted these a contract.
oh, I see what you're saying, adopted. Okay, I get it. You bought the property with them in possession. Well, yeah, you can ask them if they want to move downstairs and sign another rental agreement for more money. Otherwise, tell them that, listen, if you don't want to do that, you can put a little pressure. Then whenever your lease is over, guess what? I'm not renewing and you're going to have to get out. Anyway, thank you very much. I do want to try to get through some of these. And Domingo, how are you? I ask you to unmute yourself. Domingo. Last chance. Okay, sir. Appreciate you. Let's move on to Ehab. I'm going to ask you to unmute yourself.
Hi, Mr. Thank you for the show. I have a question. Actually, I have a tenant that he didn't pay me for 9 months, and he owed me like $9,500, and the judge only awarded me like $100 every month. And the tenant actually sent me a funny message saying, "I hope you live long enough to collect your money," which is right.
I think
Can
what
I?
you're saying is that the judge said that the tenant that you have a judgment for $9,500, but the judge is saying he only has to pay you at the rate of $100 per month. Is that what it is?
Yes, sir.
Okay, because you said it a little bit different. Yeah, the judges can, in these claim of exemption hearings, order that the tenant pay a certain amount per month based on his income. You might want to try to go in there, especially if he stops missing payments. You might want to go in there and see if you can readjust that order because it's not etched in stone. So wait a little bit, say how he's not even paying that timely, and see if you can get another judge to rule differently.
Okay, but if he's paying every month, I cannot challenge it.
I don't think so at that point. I mean, this state of California, their whole perspective is to try to put landlords like you out of business. So that's unfortunately where it is. And we are going to move on to, let's move on to Michael and Sarah. How are you? Need to unmute, Michael. Oh my God, Michael, you're pretty good at this usually. Okay, we're going to move on to Albert as our last call.
Hi, Dennis. I have an elderly woman, and she is trying to get a letter from her doctor that I need to put handrails for 2 steps to her apartment. Am I obligated to do something like that if it's
Under
a
the
big?
American Disabilities Act, or even under the California Disabilities Act, if a tenant requests what they call a reasonable accommodation to put in handrails, then the landlord has to allow for those handrails to come in. However, it's not at your cost, my friend, it's at her cost. So tell her that you're happy to allow for this accommodation, but I'm not paying for it. And by the way, when you leave, Miss Tenant, you got to take them out and patch it so that they don't exist. Anyway, thank you very much. We are at the end of another wonderful edition of Zoom Landlord Tenant Talk Radio, coming at you every Saturday at 3 p.m. Next week, we're going to be talking about serial tenants, tenants that keep getting evicted and trying to steal from landlord after landlord. I've got some wonderful examples to talk to you about. I want everybody to have a great holiday weekend. We will be closed on Monday. You guys in YouTube land, please hit that like button and subscribe to the channel. And once again, next Saturday, I'll see you. With that, take care, everybody.